Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss the importance of Section 319 CRPC and also its limitation, whether it can be used even after the judgment is reserved. So please remember, Justice 5 Judges Bench, Justice Abdul Nazur, B.R. Gawai, S. Bopanna, V. Ram Subramaniam, and Madam B.V. Nagaratna. Right? While trying a case, so in which the topic of Section 319 has come into existence, actually they have called for a report. This case is Sukhpal Singh, Khaira. Sukhpal Singh Khaira versus State of Punjab. So the dispute has come when the judgment, actually it is about to pronounce, the trial is over, the judgment is reserved. At that point of time, the state, they wanted to reopen the case, or they wanted to summon another accused under Section 390 CRPC. So the High Court says already the conviction or judgment is about to be delivered. At this stage, how this 319 will apply? Now, even the Supreme Court also, they wanted to clear the air, therefore they have given notice to the state, and of course the judgment will come within a week or so. Then we also once again we will discuss. Now, first of all, you must know what is 319 CRPC. You may be knowing. So, for example, I will give you a classic example. So, my friend Valla Mal Degra Okatano, he committed suicide. One of the workers, he committed suicide. Then my friend manager, he has given the report. A case of 306 was registered against his wife and some other person, wife contractor వాళ్ళ మీద కేసు పెడతాం జరిగింది. పెట్టినప్పుడు the owner of the mall was cited as a witness, but the APP as well as the judge also, I believe, of not only APP said no, when it occurred within the premises of the mall and within the knowledge of the so-called owner, you must make him also as an accused. You must him. So she wanted to file a petition under Section 319 CRPC. So now please remember. So during the trial, it appears from the evidence, it appears to the court from the evidence that some person who also committed offence is not added as an accused in the charge sheet, as the court can give summons to him and conduct the trial. The court may proceed against him. So this is what is stated. This is 319 here. So please don't be under the impression that suppose if police file the case against only 3 or 4 persons, the trial will be conducted against them only. No. In this connection, please remember, even 173 clause 2 CRPC, it also says that you can add the accused at the time of the charge sheet also. Suppose if the police file the charge sheet, so they give a notice to you. You may be knowing, according to the final report 173, you must be supplied or you must be at least informed about the stage of the case. That means whether they filed the charge sheet, whether they referred the case, if they filed the charge sheet, on whom they have filed the charge sheet, all these things. Then when the court gives you notice, Are Baba, your case, you have given a FIR about against 11 accused. Police filed charge sheet only against 4 accused. Are you satisfied with the investigation or not? Or do you have any objection? Like that, the court will send a notice to you. Then you can raise objection. I am not satisfied with the investigation of police. I wanted 11 persons as accused, but they have involved only 4. If you raise objection, of course, it is the discretion of the court. The court will decide the police investigation is 100% correct, though we can't add them. If you raise objection, if they are satisfied, they will add those 4 persons also. Like that, things will happen. So now, as far as 319 is concerned, whenever the court feels that any real accused is not lugged in, they can call them also at any stage of the trial. But here, the trial is completed. Now we'll come to the facts of the case. Actually, on 5/3/2015, an FIR was lodged against actually 11 accused Actually, what are the offences? For the offences under section 8C, rated 20B of NDPS Act 1985 and section 27 of Arms Act also. And also, they have added some other section of Information Technology Act 2000, right? So, actually, the FIR was given against 11 accused. The investigation of the police, they have filed the charge sheet against 10 accused only. So, therefore, they deleted 1 accused, right? And actually, even there was a second additional charge sheet also, where they did not name this person also. 2 charge sheets were filed. That is, additional charge sheet was filed. You know, any number of charge sheet filed can be filed even before the conclusion of the trial. Right. Then, the trial court pronounced the judgment and convicted 9 accused. 9 accused. This is the stage. That's all. They did not give any sentence. You may be knowing section 235 CRPC. They have to hear about the sentencing also. So they were convicted. That means the offences were proved against them. At this point of time, the state wanted, they filed a petition under section 319 CRPC to add the 11th accused also. So this is this one. So then normally the accused persons, that is who is this man, Sukhpal Singh, they have filed an objection or they have filed a application or appeal before the Honorable Punjab and Haryana High Court. Right? Punjab and Haryana High Court allowed the petition. Now the point is whether the court has got the power to call for or to allow the petition under section 319 CRPC. And please remember, in this issue, Sri Nagamuthu, he has been taken as amicus curiae. He said, please remember, trial comes to an end only after acquittal or conviction. So here, the case is proved, that's all. That means the conviction should be there. But still, yes, 319 CRPC can be filed. So, this is the opinion of the amicus curiae. But the Honorable Supreme Court of India is also in dilemma whether 319 can be applied or not, and they have given notices to other party. So they will take the response from the other party and then they will decide. I will come back to you. So what you have to learn in this Sukhpal Singh case is whether the reopening of the case can be done even after the judgment is reserved. So this is what's called. Please don't mistake it as section 311. Section 311 CRPC also says about the reopening of the case. For what? For re-examination of the accused. Suppose a police officer doesn't come to the court on the dates of adjournment, the case will be closed. Prosecution case will be closed. Later, he comes to the court on the next date adjournment and he files a petition under section 311 CRPC. It will be allowed. So please remember, 319 is not equal to 311 CRPC. If you know this much, it is sufficient. Thank you very much.